Good afternoon, everyone. Welcome to our fourth Thursday webinar in our continuing series of the 11 Commandments of Asset Protection. We had somebody who was having difficulty getting on, so we're just trying to get that person set up here. We have quite a few attendees we see already logged on. I am Eric Boughman with the law firm of Forster, Boughman, and Lefkowitz, and my co-presenter or co-host today is Gary Forster. Gary, can you say hi to our...
Hi, how we doing? Gary Forster, Forster, Boughman, and Lefkowitz. Today is commandment number 8. Actually, of all the commandments, this is probably the least technical, but maybe the most important, especially for your day-to-day client. I'm talking to CPAs and financial planners. These are some pearls that in every meeting associated with protections you probably should walk through or have us walk through. So we have an introductory page.
And so we'll talk about what we're going to do today. And this is some of the basics. This could actually be maybe the first commandment, but you know, as we go through some of these issues, some of the stuff we'll talk about today, broadly, we talk about in more detail in other webinars or seminars. But we'll talk about the use of titling, and we'll talk about statutory exemptions, general basic trusts, and then protective entities, including corporations and charging order protected entities. We'll touch on the interplay of insurance with asset protection planning, and we'll conclude with some questions. And don't let the question portion at the end here make you hold all of your questions. If you do have questions while we're going through this today, please let us know throughout the seminar, and we will be happy to address them. You can type them into your into the box in the GoToWebinar control panel, and we will get those questions and take them as we hear them. And
we have these topics are very broad. We today are focusing on some of the more simple and effective protective measures, but like Eric said, if you do have a question on a more technical issue or you want us to speak more on any topic, just let us know.
And also another note, we do have a CLE number that we will announce at the end of the day or at the end of the webinar, and if you're looking for credit for CPE credit for the CPAs that are listening, please let us know. We'll make sure you get the required form for that, and then we'll have the CLE credit information for the attorneys. And with no further ado, we will move on and talking the introductory comments here. And Gary, you want to talk about some of the advantages of keeping a plan simple?
Well, a lot of the cases we've been dealing with over the last 8 to 12 years really arise because of complexity. In other words, if the defendant / debtor had done some very clear, simple planning before all of the clouds started to form, oftentimes there would never have been a case. It just would not be a penetrable structure, because these are things that people do day to day. Sometimes you do it for other purposes or for combined purposes, such as estate planning or business, corporate type structuring. And what you find in those cases is that just the pure aspect of having an exotic portion of their asset protection plan kind of raises certain flags under certain situations. I mean, in other situations, some exotic formats are very prudent, but almost always those exotic formats are also combined with a lot of this simplistic planning that are applicable to people of little or astronomical wealth.
And some of the things that we've talked about in prior webinars are some of the more exotic plans and we've shown where sometimes that can actually backfire. And so today, hopefully, we'll be able to give you some stuff that you can do in your general practice and some ideas to simply protect your clients. So one of the first that we'll touch on here is entitling and the advantages for those in Florida and other states that have tenancy by the entirety, and the advantages of TBE titling for husband and wife. And Gary, can you talk about that?
Yeah, on most of the East Coast, the English common law, which existed in around 17 to 1750, was pretty much adopted by the states. And what that means is you could, as two people hold property together in common, that's called a tenancy in common, you could hold it as an estate planning, with an estate planning motive, whereby the survivor receives the property without having to create a will, and that's joint tenancy with the right of survivorship. And then husband and wife can hold property. Before we had the complexity of planning, we had what was known as the dowry system, early U.S., in early U.S. history and throughout the English common law history, where a wealthy man would wanted to take care of his daughter. Women could not do certain things with property. They couldn't hold certain title, but what they could do is hold title with their husband. And the early purposes of the dowry allowed for tenancy by the entirety, which did not allow the husband to sell the property without the consent of the wife, the daughter of the wealthy lord or whatever, aristocrat. And so they created this tenancy by the entirety. The dowry would be paid by tenancy by the entirety, and any claim against the husband was not could not allow the creditor of the husband to reach the property. The same would be true for the wife. That was so popular that it was adopted into U.S. common law. And now we have, with husband and wife in the states that have adopted it, these are typically states that stuck with this English format and didn't go with what's called community property. That's where husband and wife are deemed to own all assets and debts. So in Florida, for instance, in several states up the coast, if husband and wife elect, they can hold property together, and a claim against either but not both cannot reach the property. So it's a very, very simple, easy way to guard against a claim against a spouse who is in a high-risk business. So if the property is held together, the creditor or the plaintiff against the one spouse cannot reach the property held by both. If it's properly held, tenancy by the entirety, TBE.
And the entireties, generally to touch on those, and you can look these up, but just so you're aware, it has to be joint possession, ownership, and control of an asset. The interests are identical between husband and wife. Title has to have originated in the same instrument. So a common error you may see is husband or wife, somebody owns property, and a piece of real property, and transfers title or a portion of that to their spouse. That doesn't work. If the husband's transferring property to the TBE ownership, the husband has to transfer from husband to husband and wife as tenants by entireties.
Well, and that in Florida probably works, but in some states even that won't work because it really doesn't originate in the same instrument. For the big kicker, Florida adopted a statute where there's a presumption of tenancy by the entirety. But the big kicker is, wife has a big bank account, right, before marriage. There's a marriage. Wife says, I want to add husband to my bank account and I want to hold it by the entireties. Well, that's a problem because the unities, the origination of that original account, that was wife's account. So it's not held together from day one. So from basically day one, you have to have the unities of interest. It's a little technical, but if in fact you do run into a creditor problem, these 6 unities will be worked through in litigation. If you have any questions on that, you can post the question, but basically you have to start with a new document where both contribute in a new account, a new stock certificate, where you kind of have a commonality from day one.
And let me address, we got a couple of questions. Somebody asked if we were going to provide slides. We did provide a copy of the outline. The slides are very broad. There's a lot of colors and pictures, and therefore our talking points, we have it. I can, if somebody has an interest in having those, I can have them printed and provided afterwards. But the outline that we have shared through the GoToWebinar, that outline has everything that we're going to talk about today in much further detail. It lists out, for instance, all of the entireties that we're talking about now. It will list the statutes and cases that we refer to throughout the webinar. So hopefully that will be sufficient for everyone. And if you have any other questions, keep them flying. And hopefully everybody can hear us. If somebody's having trouble with audio, please let us know again in the question box, because according to our indication here, the audio is working. So in covered entireties,
now you have your barrier to charging order, which is a very interesting concept.
So every week or so, we're presented with someone who started an LLC, for instance, and said, well, I added my spouse for 10%. No one's ever sure how they come up with these percentages, but what they've done is they have not eliminated the exposure of the LLC, which is if an owner is sued on a matter unrelated to the business, the plaintiff can get a lien called a charging order on the membership interest, and any distributions associated with that interest are taken by the creditor. So you can't make a distribution when the membership interest is liened. One way to deal with that is to place the equity of the LLC in tenancy by the entireties. So if in fact one spouse and not both spouses are subject to litigation and get sued and lose a suit or have a debt, etc., there's no way to place that lien or reach LLC assets on the LLC equity. The plaintiff would need a claim against both husband and wife. And that's a very, very significant point, only because we just see every day how, we had one yesterday actually, how people are exposed to that issue. And it's a very simple, effective thing to do. A lot of people are worried about, you know, if I get a divorce, well then my wife, or my husband, whatever, is going to claim. No, that's actually not how it works. If in fact that equity is acquired during the marriage, it likely becomes marital property anyway, and the spouse is going to have a claim to that, at least the value of that interest. But holding this stuff, TBE, is very, very, very effective.
So another easy way with respect to, actually let's cover a little bit more on TBE, just with some of the presumptions. So if you own real property as husband and wife, particularly residential property or homestead, by statute that's going to be presumed to be owned by husband and wife. If you own stock certificates, there's a presumption for husband and wife. And bank accounts is kind of a unique one, as Gary talked about. There's issues that come up with transferring an interest in bank accounts, but I'll point out another thing that comes up is some banks do not have an option if you go to open an account for TBE. And it's important that you select TBE if it's offered, if that's what your intent is. And we've seen people who, if the bank offers various forms of accounts and you select a joint tenants with rights to survivorship, which sounds a lot like TBE and is very similar to TBE, except it doesn't have the element of marriage is not required, and it doesn't have the same protections as TBE. If you choose that type of account, then and you later are challenged and you try to say that your intention was to have a TBE account, a court will find generally if you had the option to select TBE and didn't, that you intentionally did not select TBE. However, if TBE is not offered and you select something else, then a court very well may engage in further inquiry as to whether or not your intention was to have a TBE account or not. And so,
or you could just skip the bank.
you could skip to go to another bank, or you could do one more thing. And I did this. There's actually it's Charles Schwab. If you go to fill out an account information online, they do not offer a TBE account option online. But I called somebody over there, and as it turns out, if you call and ask, they will send you the form for a TBE account. My thought is that probably a lot of banks don't like TBE accounts typically because there's additional liability in a circumstance where, let's say, the husband or the wife individually gets a judgment and somebody comes and freezes or tries to garnish that account, and the bank freezes it or doesn't acknowledge, doesn't comply with the TBE protection, then the bank could be on the hook. And so they just don't really want to deal with it, and some banks just won't give you the option to have a TBE account. So having covered that, let's talk about transfers to spouses. This is actually kind of a little colorful case of where people can sometimes overthinking this can be a little complicated. So in this Grief v. Becker-Polikoff, this was a case that actually was in the news a little bit a couple of years ago. We've talked about this one before, but the interesting thing here is the person subject to a collection action in this case was trying to protect assets. He had gained some assets out of the Bernie Madoff incident. And so the Madoff trustee, in trying to recover assets from the Ponzi scheme, was bringing actions against various investors to recover the funds. And this individual was trying to protect his assets and went and hired lawyers, or thought he hired lawyers, and that was part of what the case was about. Thought he hired lawyers to help him protect the assets, and they suggested that he transfer all of his assets to his wife under a post-marital agreement, and then his wife could move the assets offshore and they would be protected. And that's a circumstance where you have to kind of scratch your head. And here in Florida, we have the simple, if you're going to do something like that, you could at least make them TBE assets, and it would provide the same protection. If you have TBE assets, or if the assets are in your spouse's name, they're not going to be subject individually to collection against the individual spouse.
Well, it's a red flag, because anytime we transfer like that in the middle of a problem, we question the advisor, because there are other ways to reach those assets as well. But also, the circumstances under which this happened were pretty questionable, and the individual who had all the money ended up not having any money at the end. And I think probably the lawyer faced the music on that one.
Yeah, and so what do you think happens when the husband transfers all of his assets to his wife? He's subject to a collection action. Naturally, 3 months later, the wife files for divorce, and now she's got everything, and now the husband's dealing with this collection action with no assets. As it turns out, in that case, the wife actually got drug into the case because the trustee sued her as a transferee of a fraudulent transfer. And then she sued the husband on indemnity pursuant to the agreement by which they transferred the assets. Sounds confusing, but the upshot of it all is that there was really no benefit to transferring the assets to the wife, and it really probably made it look worse. In fact,
it was horrible.
Had he transferred the assets, in some circumstances, if you transfer from husband to husband and wife as TBE, or vice versa from wife to husband and wife as TBE, there may be an argument that you could raise that marital funds are used as consideration for part of those transfers. And you don't have that argument available to you necessarily if just one spouse or the other takes title. So, lesson is to use TBE when available. Other exemptions, and these are mostly by statute. There's an exemption for wages for head of household. There are also some wage exemptions under the garnishment statutes in federal law, retirement plans, education plans, annuities, HSAs, disability, and life insurance. Although life insurance is protected, there's limitations on it.
Yeah.
Protection does not extend. Gary, clarify that.
Well, life insurance is very tricky. I want to go back to the Homestead, though, too.
Well, we have a whole, yeah.
Oh, I think we have a whole section on Homestead.
Okay,
we have a whole section on Homestead. life insurance is very tricky depending on where you live. In Florida, the cash value is only protected from creditors of the insured. So, you know, a lot of people think, okay, we're going to do like a cross-purchase arrangement for our very valuable business, and we're going to build up cash value. I'll buy a policy on you, you buy a policy on me. But what happens is one of the guys gets sued, and his policy benefiting him is not owned by him. It's owned by the other guy. It's a cross purchase, and the value of that policy for cash value is not his, because it only benefits the cash value of the insured. The same is true on some of the life insurance payout issues. You have to be very careful that once the payout occurs, that the actual proceeds are protected. Now, you really have to work through the statute depending on which state you're in. It may be such that if the proceeds go to someone other than the insured, like the daughter of the insured, well, she may be in the middle of litigation. So those in Florida, if she pulls out cash value, that cash value is exposed to her creditors, or she may have a judgment against her. You have to be very careful with that. Of course, we work through that in the planning process. If in fact there are children that the intent is they would get an immediate payout from a life insurance policy, that would be held in trust. So actually the policy would be owned by a trust, and the proceeds would pour into the trust, and the trustee would have discretion on making distributions to the daughter. To be very careful with this, and it's one of those tricky things that varies wildly from state to state. That's life insurance. Annuities are the same way. Annuities are highly protected in Florida, but many states have tremendous limitations. And also, besides this beneficiary limitation, they have value limitations. So someone gets paid out $5 million, but only $500,000 is protected. You have to take a hard look at that. It's usually linked to the residence of the owner or the beneficiary, depending on the state. But sometimes you can, play around with where the annuity is held through different trusts formed in different places. That's another seminar, by the way, that we do on jurisdiction. If anyone has a jurisdiction question, we'll take that, but that's a different question. These exemptions, apart from life insurance and annuities, are usually pretty straightforward. Like we have health savings accounts in Florida, both the 529 and the prepaid are exempt. For Florida residents, you could be sued, and that stuff is not going to be available. Do you have anything to add on there?
No, I think you've covered it. We'll touch on homesteads here because that deserves its own discussion. And rarely does a seminar or webinar involving asset protection come up when we don't talk about the homestead protection. But in a seminar like this, where we're talking about some of the basic, simple things that you can do, I mean, you really got to focus on the flexibility this provides as well. And so, the homestead, firstly, constitutional protection here in Florida. So there's a case from a few years ago. Now it's actually getting long in the tooth, about 10 years old, Havico, where the question came up, if I am subject to a debt, transfer property while I'm subject to the debt, or not transfer property, excuse me, make a transfer such that I buy a homestead in the middle of the lawsuit or at the end of a lawsuit after I'm subject to the judgment, can the creditor unwind that and take that asset back? And this was somebody who moved from, I think, Tennessee and moved to Florida. I think it was this Havico Hill, moved up on the Panhandle, bought a big, expensive property, and the court said this is a constitutional protection. It trumps the fraudulent transfer statutes, and you cannot take that property. There are some exceptions to that, but this is why the joke, the running joke that there's a reason OJ lives in Florida or lived in Florida. I guess maybe he'll move back now that he's out of jail, because the homestead protection creditors can't touch the home. You can have a big fat pad And as long as you meet the pretty basic requirements for homestead, you're going to be protected.
But it's not just, that's true. It's not just that they can't take your homestead. But unlike any other protection in the country, Texas, for instance, offers the unlimited homestead exemption, but not like Florida. You actually can be running from a creditor. You actually can be in the middle of litigation and fund a homestead, and no one can take it. People think sometimes that they can avoid asset protection planning or estate planning, and they say, well, once we explain this to them, well, I'll just fund a homestead whenever I'm ready. But in about, what do you think, about 75% of the cases, it's a great option for part of your liquid assets if you get trapped in litigation. It's totally ethical. You can buy a big house. You can actually take your current house, all the money, segregate it, and add to that money to buy a bigger house, and it's all protected under certain rules. Generally, it's protected. But, you know, it's hard to do that with every dollar. So the idea is not to go through this, I'm running from a creditor, if I ever get into trouble, I'm just going to buy a big house. It's much better to plan. And for instance, let's say you have a homestead, you keep them. Some people say, well, should I have a mortgage? I'm very wealthy, should I have a mortgage? Well, if you have a $500,000 mortgage in a $3 million house, one interesting aspect is, well, maybe part of your like, let's say your Morgan Stanley account is exposed. It's just part of the deal. You need it exposed because you want it liquid and you want direct access to it. Maybe you have a prenuptial agreement. Well, if you run into litigation, you think you're going to lose some large judgment, that $500,000, you can just pay off your mortgage. And all of a sudden, that $500,000 of liquidity that was exposed becomes completely protected. And then you've done your planning, so the rest of your assets are very hard to reach. It's just it's kind of a last-ditch thing, but it's something that no other state offers.
And you know, here's some other things with homestead too. And what Gary's talking about is paying off the mortgage or putting any cash into the homestead. That's all protected. Improvements that you make, if you add to the property, that's protected. The creditors can't touch that. And the exclusions, I'll touch on those exclusions. If you take money, well, if you have a mortgage or a lien on the property, that's an exclusion. So you can't defend against a mortgage foreclosure on your home.
Any voluntary lien.
Yeah, any voluntary lien, you know, with the homestead protection, and you can't funds coming from fraudulent action are also not protected. So you can't commit fraud and use that money to buy a homestead. But otherwise, you're protected. And so it's not just the homestead, but there are some flexible things that you can do around it. For instance, we had one client that was involved in farming. So, you know, what other types of properties might you use? It doesn't have to be exclusively homestead. There are some Florida cases where multifamily properties have qualified for homestead protection. So if you own a duplex or a triplex, maybe you have some rental units there, and that qualifies, although there's a case involving a property over in Daytona Beach with a 6 or 8plex, and that was not protected. Farming property, we have a different homestead protection. If you're within a municipality, you get a half acre, and if you're outside of the municipality, you get 160 acres. And the reason for that is that, you know, that Florida has a public policy that protects rural activity and farming. And so can you own a property and have it protected as a homestead and operate a farm for profit? And the cases overwhelmingly say yes. What if you aren't really into farming, but you own this big property and you want to rent some of the land out for farming? Would that be protected? So this would be fun if we actually had a live audience here. But I will tell you that the answer to that is yes, that will be protected. If you rent a portion of your rural land out for use as a mobile home park, there was a case where that happened, and that land was protected as homestead. Interesting way to use the property. And then one of my favorites, the adult nightclub with the upstairs apartment was not protected. So there are limits. The courts finally say, we're not going to protect everything. And then finally, I talk about another strategy that I went through with some clients, you know, almost inadvertently. It just sort of happened and it got me thinking. let's say you're husband and wife. Husband becomes subject to a big judgment for one reason or another, and the husband and wife have a homestead, have their own property. Well, then maybe they want to invest in real estate. If they go buy another property, potentially that property, there could be some exposure with the judgment creditor. Or if the husband, tries to do it himself. But one thing you can do is you've got homestead, that's an exempt property. You can now move out of that property, buy a new property, because the homestead is exempt, use that as a rental property or potentially transfer it into another protected entity, and you're going from exempt to exempt, and there's a good argument there that that is going to be a protected asset against creditors, even in the face of a judgment, so you're not subject to fraudulent transfer unwinding. And I don't really see, I guess that'll come up one day in court. I haven't seen it, but theoretically you could do that over and over again. You could have a home, even if you live by yourself. You could have a homestead and have a little apartment, transfer that thing into a trust or an LLC or do something else with it, move out, buy another bigger property. It's a homestead, and that one, it goes from exempt homestead into an exempt or a protected entity, and repeat that process.
Yeah, it's the argument against that is you've given up that homestead at some point. But it's an interesting thing that I'm sure we'll have to litigate at some point. A way to illustrate that is what had happened during the mortgage crisis, where people weren't paying their mortgage. They had a homestead, they were completely underwater, but that some of these people actually earned income, so they would save income. As the litigation progressed, they realized they were going to lose their home and suffer a judgment for the deficiency. They would actually owe more money to the bank. They would actually take their savings. We don't do this, but it's just an illustration. They would take their savings and buy a new homestead, move in, at the new lower price across the street, and have substantial equity, and abandon their old homestead. And if all of their exposed assets were put into the new homestead, there was very little that the bank could do. This was one of the issues that created a tremendous obstacle for the banks in the mortgage crisis.
Let's see, we touched on some of the other issues with homestead. Courts have allowed parcels to be combined, so if you have a homestead parcel and acquire the parcel next door, especially in a rural area, and just be aware that there's limitations in bankruptcy for homesteads.
Another point on a limitation, that's a good point, is there's a case of someone pouring money into a homestead in Palm Beach, but they ended up taking an acre, and what's protected in a municipality is 1/2 acre. So what they ended up doing, the house was so big that it actually took up a 1/2 acre. The footprint took up a 1/2 acre on an acre lot on the ocean in Palm Beach. And they claimed that the 1/2 acre that the house was on was what they got in a foreclosure sale. So the judge, because they were on more than a 1/2 acre, allowed the foreclosure. But the judge says, no, you can't just take the lion's share of the proceeds. You're going to take the proportion amount of the whole. So in this case, their house was on 1/2 acre. There was a 1/2 acre protected, but the whole property was an acre. So they got half the proceeds of the foreclosure sale.
Let's talk about change directions here a little bit. Talk about trusts, and this is the traditional form of asset protection, your traditional trust with a spendthrift provision. In the traditional trust scenario, you have a settlor or grantor of the trust who names a trustee and a beneficiary, and you split the equitable and legal title and property, and that provides protection so that the beneficiaries can enjoy the benefits of the property of the trust, and the trustee has a fiduciary responsibility to protect the trust assets for the benefits of the beneficiary. And it provides a protection against creditors who might otherwise try to take title of the beneficiary's assets, and also protection against the trustee who has no right to enjoy the assets other than to protect them for the beneficiary. What we see in Florida a lot are the living trust or the revocable trust, and Gary can explain why the revocable or revocable trust is not an effective asset protection mechanism for the person who establishes that trust.
So the traditional trust creates this what's called divided title. So someone, a grantor, founder of the trust, funds the trust for somebody else. Okay, so father funds it for son, but appoints a trustee to control the assets. So the trustee, if the trustee is sued, the trustee has no ability to legally benefit from the assets, so there's nothing to get from the trustee. If the beneficiary is sued, the trustee has discretion over what happens with the assets. So the beneficiary says, I don't control anything, so you can't get anything, and all the assets are completely protected from suits against the beneficiary. But that's based on the English common law that developed for 500 years, beginning about 1450. And so this went on forever, for basically, half a millennia, where you couldn't form your own trust. If you put money away for yourself, or you controlled the money, you could take the money out. Creditors who sued you could take the money. The trust has to benefit someone else through a third-party trustee. Revocable trusts are basically just fancy wills. I mean, weekly we have people come in and say, I have a trust. They have a revocable trust. They have a will when they die. It will allocate the assets where they intend that they go when they die, but while they're alive, those assets are completely available to creditors. So in the 80s, a few offshore jurisdictions allowed the self-settled trust. You could fund your own trust. So you would open a trust in the Cook Islands, appoint a trustee, and the law of the Cook Islands said if someone sued you, as a settlor, founder of the trust, those trust assets are not available. And there's a variety of cases. Typically, those assets are protected if they're offshore. Some of the cases allowed for other assets to be seized of the settlor that were domestic U.S. assets. There's a whole variety of outcomes. But generally speaking, those assets are protected. If they're offshore and they're with a foreign trustee in a foreign trust, there's very, very few examples of someone actually reaching those assets. In fact, so much went offshore that Alaska, Delaware, Nevada started to offer the trust. Now we have 16, I think it's 16 or 17 states now offer a self-settled trust. You can create your own trust. The law is kind of slowly developing on that, though. And what's happened is, if you don't live in the jurisdiction where the trust is formed, for instance, Florida does not allow a protective self-settled trust. We're not sure if it works. If you don't use a trustee in that jurisdiction, if the assets are not held in that jurisdiction, if the beneficiaries don't live in that jurisdiction where that trust is offered, like Nevada or Delaware, it could create weaknesses in how the assets of the trust are protected. So the moral of this slide is, if in fact you're trying to fund a trust for somebody else, that's the principal goal. Maybe you want access to a small portion of the assets. Just keep it simple. Create the trust for someone else. You can create it in a strong trust jurisdiction, and the likelihood of anyone ever reaching those assets is very, very small. If you go with a self-settled trust, especially domestic, you could expose them. And of course, offshore trust planning, we do a huge amount of offshore trust planning, but it's expensive as well, and it usually requires at least some minimal amount of money. We often say some portion of your wealth should go offshore, just as kind of a bomb shelter type thing. It's more complicated, it's more expensive, but it is quite protected.
And we have a note about, there's all different types of special purpose trusts, and land trusts, and irrevocable life insurance trusts, and gun trusts, and we get asked questions about different trusts. The land trust is one that people think of for asset protection, but it really, we've gotten a lot of questions on that one lately. It really doesn't add anything under the typical land trust. It's oftentimes settled by the beneficiary, and Florida doesn't recognize any asset protection for self-settled
It creates
trust.
some anonymity with the deed, but that anonymity is much, much easier to create through an anonymous LLC such as Delaware.
And in my experience of having spent a couple years, unfortunately, representing beneficiaries contesting a life insurance policy involving an irrevocable life insurance trust or an ILIT, if you're going to use something like that, it's advisable to engage counsel or somebody who knows what they're doing. It was really a sad story when you have to litigate and you end up in a situation where the beneficiaries have to fight for any insurance benefit. So Gary talked about the domestic asset protection trust a little bit and the offshore asset protection trust. Understand that self-settled trusts in the U.S. are only recognized in a minority of jurisdictions. We have it scheduled, I believe, for next month. The Commandment number 9 is know who and how to trust, and we're going to talk for an entire hour, if this is your thing, about trusts, and it'll be mostly dealing with the asset protection, the domestic asset protection trust and the offshore asset protection trust, and some of the keys for effectiveness of those trusts. But Gary kind of hit on the general points today, and that's use the basic trust with the basic protections involved. So let's take a little bit of time that we have here, and let's see. Oh, okay. Somebody had their hand up, by the way, and I tried to address the hand up. I try to address questions, and we see the questions as they pop up. But if you have a question, you drop it in the box. We'll address it. And we don't we monitor. I'll address some of these questions that some people have asked that are not relevant to the substantive material. We have not done a poll. We do monitor the who is attending and who is attentive on the app for the GoToWebinar. But if you haven't missed a poll, so don't worry about missing a poll. And I can answer more questions about that offline. I want to stay on topic here and deal with the protective entities, and these are corporations, LLCs, partnerships. And first, corporations. This is the typical entity that a lot of people think of first for limited liability protection. And Gary, you want to talk about the distinction that the corporations have versus charging order protected companies?
Sure. The corporation formed over, basically the first couple hundred years of this country, everybody used a corporation. The corporation is a great idea with respect to operating a business in terms of protection from business liability. So if you have a vendor or a problem with your corporation, if you operate it properly, you're not going to be personally liable. That's called inside asset protection. The problem with corporations, which has now become very pronounced in light of the new LLC, is that if an owner of a corporation, whether that be IBM or your local corporation owning a gas station or some small business, is that the stock's totally available to creditors. It's every week someone's shocked that we tell them, you've been sued, they're going to take your corporation. What do you mean they're going to take my corporation? It's just like you have an IBM stock. They can take the corporation. The real significant difference between corporations and LLCs and really partnerships are seldom used now because they actually can create a lot of liability, but is that the significance between the corporations and the LLCs is that if someone sues an owner of an LLC, provided in Florida that it's got more than one owner, the equity and the LLC assets are not available to the creditor, this outside asset protection, as opposed to a corporation where the stock's completely available. They could be liened. The equity there can be a lien placed on the equity, but there's no, at least no case that I know of at this point that requires the LLC to make a distribution. In other words, the only thing a lien holder has in Florida, and almost all the states, this is true, some states allow for foreclosure of the interest, but is the right to take a distribution if one is made. So unlike a corporation where you lose your stock, if you're sued, you basically just get liened at the worst and threaten never to make a distribution, and there's not, I think we've seen a settlement almost every time when someone sues and tries to take an LLC. Those are the main differences associated corporations and LLC. Eric can go through when you guys, when owners get into a scream out, how exactly, what the theories are, pierce through and take LLC interest.
Yeah, typically to take a corporate or LLC, if you want to pierce, and when we talk about veil piercing, we're talking about you form a corporation or an LLC or a limited liability partnership, and the company is sued. To what extent, if any, are the individual owners, shareholders, members, to what extent will they be held liable for the actions of the company? And the corporation provides basically the same protection that an LLC provides on that regard. And in a way you get through and get to the individual owners is through veil piercing. And veil piercing occurs, there's basically two different standards throughout the country. One is that if you don't recognize the corporate formalities and you treat the corporation essentially as, you don't treat it as a separate company, a court can look through the corporation. This typically occurs when you have intermingled funds. You're using corporate funds for your own personal expenses. You're mixing the bank accounts. You don't have your meetings. You don't keep your required documents, minutes, and so forth. Then you run the risk of veil piercing, where we say, okay, the corporation did something wrong, and we're going to look through the corporation and go after the individual owner or owners of the corporation. In Florida, we fall into one of these jurisdictions where the standard for veil piercing is higher. In Florida, you typically have to show not only the intermingling of assets and failure to follow corporate formalities, but that has to be coupled with the use of the corporation for fraudulent conduct. And it's a pretty high standard. And so as long as you're not using, you don't create a corporation or another entity and use that as a vehicle to scam people and rip them off, you're going to be protected. Even if you don't follow the corporate formalities, although you run the risk. And I've been involved in situations several times where individual owners, you see this oftentimes with small companies, mom and pop shops, where they don't follow the corporate formalities, and a creditor will try and sue the individual owners. And if you haven't followed corporate formalities and you're dealing with just a question of whether or not you've used the company for a fraudulent purpose, it makes it a much more difficult case. Whereas if you follow corporate formalities, it makes it very easy to get those individuals out of a lawsuit pretty efficiently, a typical case. Alter ego is very similar to veil piercing. It's like what it sounds. You treat the company like an alter ego of yourself, and then reverse veil piercing is what Gary talked about. And that's not the going through the corporation and holding the individual members responsible for the corporate debt, but the other way around. The individual has liability, and we're going to take their business interest, and corporations are subject to reverse veil piercing. And Gary's already talked about charging order protected entities, and that includes partnerships and the limited liability type partnerships. Just a note on, I think, general partnerships without, that are not a limited liability partnership, they provide no protection at all. It's like a sole proprietorship, and you want to avoid that. But LLCs are really the entity of choice under a charging order protected entity. And we have a couple minutes left. I want to make sure that we address any other questions that we have about LLCs. If anybody has a question, or Gary, any other points you'd hit on? And this kind of sums it up.
Well, I think so. It sums it up nicely. Be very careful with the single member LLC statute. It really does open up equity in the LLC to creditors. So there was a case, Homestead, where the Supreme Court kind of went off the ranch and completely exposed the single member and potentially the multi-member LLC. They had to revise the statute. It was such a bizarre ruling. But they left the exposure on the single member statute unless you can prove that distributions to the lien holder are reasonably likely, which no one knows what that means. So the single member equity is very exposed, so at a minimum you do want to involve a second member. We touched on the choice of law issues. Which LLC do you choose? Eric and I go through this all the time as a planner versus a litigator. The different LLC statutes protect in different ways, so we tend as planners to choose the most protective. Whether that protection is going to be respected by a court in another state now has become
at least a marginal question. But we still do recommend, you know, if one state says the single member is protected and Florida says it's not protected and you have to use a single member, go ahead and use the protected one. I'm not sure what exposure that's going to create. These kind of issues only come up if you seek an advisor who really is going to try to find the optimal structure for you. And we just recommend that at every level. I think we've had about 52 minutes, something like that. If you have any questions, we can address them. We can wrap up.
We got a question.
Oh, we do?
We have at least one, if anybody else has any other questions. And we have one other slide, actually. We were going to just hit on insurance. We get asked sometimes about the use of insurance, and basically the insurance can supplement your asset protection plan. So, you know, it's really using both. You want to operate in a protected entity. You want to keep, you know, generally assets that you want to protect personally protected in some type of trust or other similar mechanism, or at least have them titled for protection, and take advantage of the fact that oftentimes insurance is a cheap way to protect yourself from claims. And I'm going to throw out, here's one question. I'll reword this that somebody put up, and they asked if we would use multiple corporations for a situation of somebody who owns a restaurant and owns the building and owns the equipment. Would you split those into different corporations? At first, you would use typically the LLC instead of the corporation. And business operations, and Gary does a lot of planning, so I'll let you address that. If you have a restaurant owner, and they also own the building, and would you have them run operations in the building and the equipment through different entities? Or how would you do it?
I would divide it to the extent it's reasonably, you know, doable. If it's efficient and it works for them, you always want to divide it. Surely the restaurant building would be segregated from the business, because, you know, anything can happen in a restaurant related to the operation of the restaurant in terms of, you know, all the customer issues, all the poisons, everything else, all the staff, everything. If something happens associated with the activities of the business, they're just a tenant. They're just a tenant. If you're going to have a good lease, but that plaintiff, which could be significant in some cases, especially in a restaurant or supermarket, could have a pretty big claim and would go after the building, would have a very hard time reaching the building in a typical case. The equipment, there's nothing wrong with segregating it. I think it's harder to argue that it's not part of the business. In reality, I think if Eric had a case like that and was acting on the plaintiff's behalf, he would argue that that's just really a sham. It's just part of the business. I think it's very hard, though, to get to the real estate. So at a minimum, I'd segregate the real estate. Sometimes we can even put them under one tax return by creating a holding company that has the 3 subsidiaries, one for the real estate, one for the active business, and one for the equipment.
That's it. We had somebody else asked if they wanted clarification, looks like, on the distinctions between a LLC and the single member LLC. And so I just circle back and touch on that one, that the single member, the issue with the single member LLC is that some jurisdictions, including Florida, will allow the foreclosure of a single member LLC interest. And so the reason we don't like corporations as much as limited liability companies is because in corporations, your stock can be seized and foreclosed upon and taken from you. And in the LLC, if you have 2 or more members of an LLC, nobody can take your LLC interest. There's several traditional reasons for that. The idea generally being that we're not going to force the other members of the LLC or your business partners to take on a new partner involuntarily. So the LLC interest is protected, and the only thing a creditor can get is the charging order, which is basically a lien on proceeds to the extent that they're made. And so the savvy LLC owner who's subject to a judgment probably figures out ways to use cash for operating capital and salaries and things that are reasonable in the operation of a business, but won't make distributions, because those distributions are going to end up in the hands of the creditor as long as they have a charging order. And so you have a little bit of push-pull there. But if you have a single member LLC, in Florida and some other jurisdictions, it becomes similar to stock, where the creditor can just foreclose upon that interest and take your company from you. Hopefully that addresses that question. And somebody did, I will send out an email to anybody who's asked here for the form that you need for the CPE credit, the CLE credit number. If you have a pen and you want to write that down, I will provide that here. I'm going to just grab it. Stand by for just a moment, please. And if there's any other questions, we have a minute or two left. All right. The course number for today for your CLE credit, for the attorneys in the audience, is 1706272, as in Nancy. Again, 1706272, as in Nancy. That is for the CLE, and we will send out the CPE credit. If you have any other questions that we didn't address today, or if anything comes to mind afterwards, as you're going through perhaps the outline that we provided, please contact us. Either shoot us an email, give us a call, or reach out. We're on LinkedIn. We have a discussion group on LinkedIn. We try to monitor that for questions as well. We appreciate your participation today and look forward to seeing you next month. Also look out, we're looking at doing something, adding to this in the next month or so, in addition to having the afternoon webinar and providing a continuing education credit for that. We're going to try and couple that with a after-hours happy hour around 4 or 5 p.m. where we invite you out, where you can talk about these issues or not, and join us in a little bit more social setting. So we'll look forward to getting announcements out on that, and with that, we are ready to sign off. Thank you very much, and have a great rest of your day. Bye-bye.